In presidential campaigns, candidates make endless promises. Since legislation moves at a snail's pace on Capitol Hill, most of the bravado behind these impossible claims comes from the idea that a president can make federal agencies do their bidding. It's not really true, and it may be even less true soon if the third branch of government weighs in. The Supreme Court heard arguments Wednesday in two cases that question a decades-old legal doctrine known as Chevron deference. It means when a federal agency wants to do something, judges must defer to the wisdom of the agency unless the action is totally unreasonable. This comes up in instances where the law from Congress giving the agency authority is fuzzy or open-ended. It's a big deal, and Craig Green is going to help us understand why. He's a law professor at Temple University. Professor, thank you for joining us. How critical is the Chevron deference to the way our government operates?
Yes, John, this is a technical case, but the stakes could hardly be higher. Threatening agencies threatens almost every function of government, from airplane safety, stock markets, climate change, food and drug standards, everything. In each of these contexts, Congress doesn't set the standards itself. What it does is create an agency that goes forth and uses expertise and flexibility to prescribe how all of us should act over time. So an example is the EPA, which deals with everything from acid rain to climate change. Congress doesn't set the standards, the agency does. And for 40 years, courts have largely, as you said, deferred to agencies' interpretations of how to do the job that Congress tasked them with doing.
And so the case that those make who are in support of Chevron, of this giving this deference to agencies, is that the agencies need flexibility because technology changes quickly. They have expertise. They can move with the pace of modernity. And if you kick everything back to Congress and wait for it to give authority to the agency, it'll never keep up with the pace of change. Is that essentially the argument?
That is one part of it. I mean, Congress can barely keep the lights on in the government, much less can they decide how to regulate the environment or unions or meat safety or all of these kinds of things. And so again, for over 40 years, indeed all the way back to the New Deal, Congress and democracy has not tried to set statutory standards. What they have done is create agencies. And the court's role, which is what's before the Supreme Court right now, is the court's role has been to step back from those things and allow the agency to do the job that Congress and the American people need them to do. In striking down agency deference, the Supreme Court will cut off dozens, if not hundreds of agencies at the knees and stop them from filling in gaps and setting standards and doing what Congress and the democracy wanted them to do. It will change American government as we know it with very large risks and costs for society and a power shift from public power, governmental power, to private power, corporate power.
And so what, though, is the argument for reducing the freedom that these agencies have?
Well, a couple of things. The main issue, which is how the supermajority on the Supreme Court came to power, is, of course, there are a lot of forces in American politics that believe the federal government should step out of American life and should not be able to meet, for example, pandemics or environmental regulation or unions or consumer protection and banking and security, all these sorts of things. There are people in American politics who believe that agencies should not be able to do these things. They cannot repeal the statutes that allow agencies to do these things. And so they have gone to the courts and seek constitutional rulings from this Supreme Court that will do the job for them. So I think there is an argument putting Congress in charge, which means leaving no one in charge, and basically getting federal government out of the business of regulating the kind of safety and democratic policy standards that have been enacted, again, for at least 40 years and maybe almost 100.
And finally, then, Professor, is there a way to split the baby on this? What's your sense of the way the court might rule? Is there a way to keep these two in balance instead of going one way or the other?
Yeah, ever since Gorsuch took the court in 2016, this has been a live issue, and experts in the field have been kind of counting the votes. And so I think right now, for sure, there are three. I think Chief Justice Roberts showed a little bit of his hand today that he might be a fourth, and I think Kavanaugh would be a fifth. And so I think that although Justice Amy Coney Barrett did not show exactly what she might have in mind, I really think that this Chevron doctrine, the Chevron deference principle, which has been around since 1984 and in larger form since the 1940s, I think that's just one more area where the conservative supermajority is having its way and transforming American government using judicially imposed constitutional law.
Professor Craig Green with Temple University, thanks so much for being with us.
Thank you.